Namaste and a warm welcome to this episode of the Indian Lawyer Legal Tips. I am Sushila Ram Varma, advocate and chief consultant with the firm. Today I bring to you a very brief episode on franchising laws in India. Franchising in India is a rapidly growing industry with vast opportunities to businessmen. Choosing the right franchise model can be a key to success for many. However, legal and financial due diligence is extremely important before one enters into a franchise agreement. Now, with the right approach, franchising can afford many businesses the opportunity to scale their businesses to a new height. Now, let us understand what is franchising. Franchising is a business model where a franchisor grants the right to operate and use its brand, products, and processes. A franchise is a legally binding contract between the franchisor and the franchisee, granting the franchisee rights to operate using the franchisor's business methods and resources. It protects both parties and outlines their rights and liabilities. Now, let us examine some of the top franchising sectors that we have in India. I would say product distribution franchising, which is Coca-Cola, business format franchising, that is McDonald's or KFC. Then you have food and beverage like Domino's, of course, again, McDonald's. Then in the retail sector, Bata, Raymond, Adidas. Educational sector, Kidsy, NIIT, Aptech. Health and Wellness Center, VLCC, Dr. Batra's, Apollo Clinics, etc. Now, the next question that would be obviously on everybody's mind, what is a franchise agreement? Now, a franchise agreement, as I already mentioned earlier, defines the terms under which a franchisee operates and covers the branding, business methods, financial obligations, and operational conduct to protect the franchise system's integrity. Now, what are the laws that govern franchise agreements in India? Typically, they would be the Competition Act, the Indian Contract Act, the Income Tax Act, the Consumer Protection Act, intellectual property laws, foreign exchange management laws, and trade secrets which are protected under the contract law. Now coming to probably the most essential aspect of this episode. What are the key components of a franchise agreement? The first would be the basis of the agreement, that is, the objectives of both parties, the grant of franchise by the franchisor to the franchisee. The third would be the duration. Generally, a duration of a franchise agreement can be anywhere between 5 to 10 years. Then, of course, one of the most important aspects, the franchise fee, which covers the initial and ongoing fees that has to be paid by the franchisee to the franchisor. Details of the operation management, the franchisor's services, that is, it outlines the pre and post opening support, the intellectual property protection, which is again a very important aspect of any franchise business, the training that has to be taken by the franchisees from the franchise managers. Then, of course, you have clauses like the advertising, who takes the responsibilities. Also, what happens when there is a default and damages. Then you also have post-term obligations, which outline steps to de-identify the franchise post-expiry. Again, royalties is another very important aspect that has to be taken into consideration. Quality assurance is probably one of the hallmarks of a franchise process, because it is quality that actually helps you to develop a method or a process that you can actually sell to a number of people. Then you would have an indemnification clause which would ensure that the franchisee compensates the franchisor in case there is any loss due to negligence. Also, in most franchise agreements, there will be geographic restrictions, that is, one cannot operate beyond a certain geographical limit. And then the standard clauses of insurance will be there, a non-compete covenant or a clause has to also be there. Now, there are different types of franchise agreements. You could choose a single unit franchise agreement, a multi-unit franchise agreement, an area development agreement, or a master franchise agreement. Now, coming to the important aspect of the advantages of a franchise agreement. I would say for the franchisee, it would be the business support, lower failure rate because it's already a proven business, higher profit potential, as these are all established brands, built-in customer base, which is probably one of the most difficult aspects of a business. Now, for the franchisor can ensure efficient growth because expansion is faster and less costly. There is a brand recognition because there are multiple outlets that boost the brand. There is reduced risk because the franchisee takes financial responsibility for new units, and access to capital as the franchise fees provides funds for expansion. Of course, there will be disadvantages to this model like any other business model, but now let us get on to the risks in a franchise business. The risks would be over-demanding franchisor who would ensure unnecessary payment demands even when it's not required, under-reporting of revenue by the franchisors where they might try to manipulate the sales, and poorly documented agreements which can definitely cause a lot of issues when it comes to disputes. Now let us understand the difference between a franchise and a licensing business. Though both of them are used widely, there is a difference between these two particular types of business models. Licensing is where the licensor grants rights to use the intellectual property or to produce its products for a royalty. Whereas franchising, the franchisor allows the franchisee to operate a branch of its business under its model, brand name, or method in exchange for fees. Now, there is another type of business that is very frequently used, which is called distribution. Now, what is the difference between a distribution agreement and a franchise agreement? Distribution agreement is where where there is a contract where the distributor purchases products from a supplier to sell to retailers or consumers directly. The key difference between the two would be the operation. Franchisees operate under the franchisor's brand. Distributors operate independently. Control, where the franchisors maintain strict control over the franchisee's operations, unlike the suppliers over the distributors. And payments, where the franchisees may pay fees and royalties, distributors pay for purchased products. Now coming to another aspect of the business, that is termination of the franchise agreement. Now, what could be the reasons? The reasons, of course, can be many. Breach of contract would cover several heads. It could cover non-payment of royalty, it could cover non-compliance with operational standards, violation of policies, misuse of intellectual property, etc. Then there could be a reason for failure to meet targets or performance requirements. Another reason could be bankruptcy or insolvency of either the franchisor or the franchisee. One can also terminate an agreement by mutual agreement, where by mutual consent they decide for strategic reasons to exit. Agreements also end when the contract term expires and it is not renewed. And of course, if there is a violation of laws or failure to obtain standard or necessary licenses, then again that would be a ground for termination. Also, like all other contracts, material misrepresentation or fraud can be a good reason for termination of a franchise agreement. And lastly, force majeure events, which is again unforeseen events that can cause the franchise agreement to get terminated. In all franchise agreements where the relationship has to be terminated, it is mandatory that the franchisor or the franchisee, that is whichever party is wanting to terminate the relationship, must issue a notice in writing stating specific grounds for termination. Franchise agreements may provide a cure period for the franchisee to address the breach. If unresolved, the termination may proceed. Now, what happens when a termination takes place? Generally, it would include returning the assets, paying the outstanding fees, dispute resolution, and audit and inspection. Now, let us dwell upon some case law pertaining to the franchisee agreements. In a matter which came up before the Delhi High Court, titled McDonald's India Private Limited versus Commissioner of Trade Taxes, the issue before the court was that could the Delhi VAT authorities claim royalties were taxable under Delhi Sales Tax on the Right to Use Goods Act 2002, treating the McDonald's system as goods. An assessment had been made by the tax authorities where they had imposed an order of rupees 13,44,684 as sales tax liability. The matter went up till the High Court. The Delhi High Court held that since a franchise agreement grants only a non-exclusive right, it does not constitute a transfer of the right to use goods. It is merely, hence, having said that, the Delhi High Court quashed the tax demanded by the tax authorities. In conclusion, I would like to say that franchise is probably one of the best models for businesses to scale. It provides a certain level of protection to both the franchisor and the franchisee, and it solves the biggest purpose that all businessmen have in mind when they're entering into a business agreement, that is success and scaling of their business. With this, I would like to end this episode, thanking you, dear viewers, for watching us week after week and giving us so much of support. If you find this video useful, please like, share and subscribe so that we can reach as many people as we can through this medium of YouTube and help many people to understand what the basic law means. Thank you. Namaste. Till we meet again at the next episode.